I will later this morning introduce America's Commitment to Clean Water Act, the bill that will reaffirm the ability of the Clean Water Act to protect the nation's waters, including the nation's wetlands. These waters support our economic well-being. They enable our quality of life. They sustain our environment for the future. The Clean Water Act has restored thousands of rivers, lakes, streams, protected drinking water supplies, preserved water quality, and water-related habitat essential to waterfowl, wildlife, and the nation's fisheries. In 1972, Congress set a goal that the nation's waters would be fishable and swimmable by July 1, 1983. Progress has been made, but we're short of that goal. 40% of the water still do not meet the goals and standards of the Act. And much of that Act was hammered out right here in this room. Chairs, there weren't as many desks then as there are today. In fact, there were, wait a while, somebody's doing something with the microphone system in the other room. Yesterday we had a hearing in Chicago where the microphones didn't work at all. Now they're working overtime. But the conference committee met right here in this room for 10 months. We hammered out every word, every paragraph, every phrase, every comma and semicolon. But in 2001 and 2006, two decisions of the U.S. Supreme Court, the Solid Waste Agency of Northern Cook County and Rapanos, threw the nation's clean water programs into turmoil, created confusion, created uncertainty for communities, for developers, agricultural interests, and put at risk the nation's ability to restore, to protect, to maintain water quality and the water-related environment. Turmoil and confusion are no way to run a program, certainly not one of this magnitude and significance. The result, increased processing times, backlogs as the agencies work overtime and work in confusion to try to interpret the court decisions. America's Commitment to Clean Water Act will ensure that the basic Clean Water Act can cover the same waters it did under the regulatory decisions in place in 2001. That's very important to be clear about. Regulatory decisions in place in 2001. Those decisions were based on a common understanding developed over 29 years of experience with the Act as agencies defined its appropriate scope. Clean, safe water is a right for all Americans, but unless we act, the law can't ensure that right. Because of the Supreme Court decisions, companies have spilled oil, carcinogens, and bacteria into the lakes, rivers, and other waters without being fined or prosecuted. Because of the Supreme Court decisions, source areas that provide drinking water to more than 117 million Americans are vulnerable to pollution. 2 years ago in this committee room, I conducted a thorough hearing in which the committee heard just about everything that was good and bad about the prior legislative proposal that I introduced. We heard from 24 witnesses on 5 different panels, went late into the evening in hearings. The bill I introduced today responds to those comments, those concerns, those questions. Among the significant changes, the bill uses the current regulatory definition of waters of the United States to establish the scope of the Act. That will avoid need for new regulation. The bill codifies an exemption for prior converted farmland. The bill codifies an exemption for waste treatment systems. The bill explicitly states that groundwater is considered separately from waters of the United States. The bill explicitly states that it does not affect the authority of the EPA or the Corps, as that authority existed prior to 2001 Supreme Court decision. The bill puts limits on federal jurisdiction by specifying the constitutional authority for the Clean Water Act, preserving the historically established federal-state cooperation. The bill removes all language related to activities. I thought that was a good way to define what we were attempting to protect and cover, but that created unnecessary confusion. It was a subject of a great many concerns expressed by witnesses. Since 1972, permits are required only for discharges, not activities. So we've taken that word out of the bill. The bill preserves the exemptions, the limitations, and practices under the Act. It is not an expansion of the Clean Water Act. The bill will not require permits for every wet area. Simply put, if it was not regulated before 2001, it will not be regulated with the enactment of this legislation. Now, there are some people and some groups that have opposed the Clean Water Act since it was enacted. It's no surprise they continue to be opposed. Their opposition to my previous bill, and those that many others have joined in co-sponsoring, not opposed to that bill, they're just opposed to the Clean Water Act. Well, we can't change their minds. But for the sake of future generations, we must assure that the Clean Water Act is not rolled back.